Hey all, I'm Richard Burnham, aka TheIndieLawyer. Welcome back to my series Lawvel 101, where today we're asking, what is copyright exactly? As computer games are ultimately a form of software, copyright is probably the most important defensive tool to protect your game and its assets. The phrase copyright infringement is thrown around the internet a lot these days, but a lot of the time people don't seem to really understand what it means to infringe someone else's copyright, or where you're able to use someone else's work lawfully. And that's totally understandable. It's a big confusing mess that isn't always the same from country to country. So let's start breaking it down. So what is copyright protection? Well, generally speaking, copyright exists to protect creative expressions from being copied by other people. This typically includes things that you write, draw, or sing. And like all IP rights, you can sell copyright, license it, and give it away. But basically what this means is you can't use someone else's content to create your own. That's it, that's the video. Now in England and Wales, and most jurisdictions in the world, copyright's an automatic right that arises as soon as you create the item in question. Now in the United States, whilst copyright arises automatically, before you can take the case to court, you need to formally register it and authorise it in your state. But it's not 100% necessary at the beginning. Now a key feature of copyright is that 9 times out of 10 it doesn't protect the ideas inside your head. You have to physically express the idea before you gain protection from it. You do this by drawing your artwork, typing your code, or writing your music. Now importantly, copyright doesn't give you a monopoly. The big misconception here is that doesn't mean that your work can't be like anything else in existence. After all, it's very difficult to come up with completely novel creations today. For example, my own game, The Requiem Network, is about a genetically enhanced human who fights aliens in space. But this doesn't mean that I'm infringing the rights of games like the Halo series, Destiny 2, or Alien Isolation. If, however, my game was called Halo 6, The Requiem Network, and my main character was called Master Chief, the entire game revolved around ringworlds designed to stop an enemy called the Flood, well, that's a different story. Now, people misunderstand that copyright doesn't mean you can't have similar themes or content within your games. In fact, if both you and I developed a game at a game jam and somehow ended up producing exactly the same game without copying the other, then that wouldn't be copyright infringement because we both arrived at the same game with independent ideas. So what in-game assets does copyright actually protect? Well, it includes things like your sprites and other 3D content, the code powering your game, any text used within your game, the music used within your game, and even things like the voice acting in your game. Now what's important to remember here is that legally each asset will have its own separate copyright protection, rather than the entire game being protected by copyright in general. Now, it's possible that your artwork is copyright infringement, but your code isn't, if that makes sense. Now in the UK, most of the law on copyright is found within the Copyrights, Designs and Patents Act of 1988. Copyright protection is only provided to certain types of creative expressions, which generally fall into the following categories. So why am I throwing loads of wordy categories at you? Well, if your work doesn't fall into one of these categories, then copyright simply doesn't protect your particular asset, and the rules about who owns the copyright and how long it lasts can also differ between the various categories. Now, unnecessarily complicated, right? To make things even more complicated, your game will have several types of creative expressions, all of which will fall into several different categories. If you write a song, for example, the words of the song will be protected by what's called literary copyright, but the song itself is protectable by musical works. It's worth adding at this point that if you're in the US, you can forget all about this category business because your legislators are much more on the ball and have simply made one list that identifies whether a particular piece of work obtains copyright protection or not. Now this category business makes a lot more sense when you go through what copyright applies to within your game itself. So let's quickly have a look at what assets fall under copyright protection and what sections they fall under in the Act. Now from a copyright perspective, a computer game is a little unusual because it comprises of a number of different copyright works, and these include the computer program, which falls within the definition of a literary work, the images that appear on screen, which fall within the definition of artistic works, and the music in your game, which falls under the definition of musical works. Now LDMA basically covers all of your game dev needs in copyright, so we'll focus on these to begin with. Now as a side fun legal geeky fact, in the European Union, the fact that a computer game comprises of several different copyright works is very important because it means that video games don't usually fall foul of what's called the exhaustion principle under EU law, which really basically gives you the right to resell software licensed to you in the EU, and therefore video game. But that's a separate video in itself. I need to stop making work for myself. So how do your game assets fall into LDMA protection categories? Well, we're going to look at 3 of them. Now firstly is a literary work, which is anything other than a dance or mime that's written, spoken or sung. And in the game dev world, this means not only your game storylines, but also very importantly, the code powering your game. Now second up is dramatic works, which include things like works of dance or mime, and includes, if you've got one, a script from your game. Love to see any games that have got dance or mime as a component, that'd be awesome. And finally, we've got artistic works. Now this includes graphics and photographs, and it's a fairly wide definition that covers your 3D and 2D game art. So, does anything that falls under LDMA copyright enjoy protection? Well, that depends. With LDMA works, copyright doesn't arise unless the work's original, which is quite an interesting concept. Essentially, this means that to enjoy protection, you have to create the work through your own skill and effort without copying it from someone else, which is something we touched on previously in this video. Now, usually for copyright to apply, you also need some kind of minimal effort in creating it in order to qualify for its protection. Although this is quite low to the point it's almost not worth mentioning. It doesn't matter whether there's no worth to what you've created, even if you're complete trash at coding like I am, you still benefit from copyright protection as soon as you write that code. Now, LDMA copyright usually gives you protection from the date of the original author's death plus 70 years following the year in which the author dies. This is the case even if the copyright is sold to someone else. So if I sold you my copyrighted idea, it would expire 70 years from the date of my death, not yours. But what if you're working on a project with someone else? How much effort do they need to put in before they become the joint author of that work? Well, the answer isn't straightforward, but generally speaking, it's a lot and a little. If they're doing more than just offering ideas and they're actively participating in the creation of the work, then they're likely to be the joint owner of that copyright. But more on that in a bit. Now again, it's usually crucial that LDMA copyright be fixed, that is, taken out of your mind, before you can enjoy its protection. A good rule of thumb with this is that it doesn't usually protect anything that's just an idea. And when you're expressing these ideas to gain copyright protection, it's a good idea to do this in a way that proves exactly what date you created it. Social media is a good way of doing that, as is taking photographs, emailing yourself, or just properly documenting your file system with dates. So we've established when LDMA copyright arises in video games, but the next crucial question is, who owns it? Now this seems simple, right? If you create something, it stands to reason that you own it. But unfortunately with law, it's not always that straightforward. And it's very easy for copyright to become fragmented amongst your team members and other creatives working on your project. Now the default rule is that the person who owns the copyright will be the author, i.e. the person who actually created it. However, there are a few exceptions to this rule, and the position is very different depending on the way in which your team or studio is structured, just to make things more difficult. Now the first exception is that if you create something during the course of your employment, then the default position is that your employer owns the copyright. Now depending on your economic views, this kind of makes sense. For example, if my job was to write short stories for my employer to publish, it wouldn't really make sense that I own the copyright in those stories. This means if you work for your own development studio and it's a company structure, more on that later, then your team won't own the copyright in the game, your studio will usually. Now this is a good way of centralising your copyright and other IP and making sure no one else owns the copyright to your game when they shouldn't. But this also means if you're developing on the side whilst at your day job, you run the risk that your employer owns the copyright, not you. But bear in mind that this is only the case with employees, i.e. people that actually work for a studio. Just to make things even more confusing, if you engage subcontractors to prepare in-game assets for you on a free or paid basis, then beware the definition I gave of copyright. This means that unless you agree otherwise, even if you've paid for it, they own the copyright. Now at best you have what's called an implied license to use it. It's basically crucial to ensure that you engage with your subcontractors in a way that deals with this problem, either by signing an agreement or making it clear what's going to happen to that IP. So what all this means is that who owns the copyright will depend on your studio setup. If you're a solo dev working alone or without any form of corporate structure, then you own the copyright of anything you create yourself, and it will normally be owned outright by you. If you're working with a team without any form of corporate structure, then you'll own different parts of the game depending on who does what, which is very messy. And some parts you might own jointly. Remember the Stickman example I used in What is IP? Well, in that scenario, if we were working on a game together, it's not always simple enough to say, well, I drew this, so it's mine, when we're both coming up with the idea jointly. It might be that you've contributed to it some way and therefore entitled to a share of the copyright. So like I said, it's messy. Now the problem with your copyright or any other form of IP becoming unclear or messy is that it becomes an issue when you come to license or sell your game to someone like a publisher. They'll ask lots of annoying questions and they may want you to transfer your copyright protection, which usually means involving a lawyer and money. Therefore, usually it's a good idea to have an agreement in place that deals exactly who owns the copyright, or have a company structure in place that it owns all of the IP, or both. So the main takeaways on LDMA copyright is as follows. It doesn't normally protect the ideas inside your head. It's got to fall into one of the categories. It must be original. It usually lasts 70 years from the year following the author's death. And companies and agreements can be used to centralise your team's copyright interests. So that's probably enough law for now. In part 2, we're going to cover what you can do if your copyright is infringed or if you infringe someone else's copyright. Now, as always, if there's anything you'd like to see in particular, let me know in the comments and hit that like and subscribe button if you like what you see here. If you don't, well, it's probably my editor Joe's fault. Catch you later.